5 seconds to go. Start. Thus, while elaborate reasons may not be assigned for grant of bail or an extensive discussion of the merits of the case may not be undertaken by the court considering a bail application, an order dehodes reasoning or bereft of the relevant reasons cannot result in grant of bail. In such a case, the prosecution or the informant has a right to assail the order before a higher forum, as noted in Gurcharan Singh versus State Delhi Administration 1978 Criminal Law Journal 129. When bail has been granted to an accused, the state may, if new circumstances have arisen following the grant of such bail, approach the High Court seeking cancellation of bail under section 439(2) of the CRPC. However, if no new circumstances have cropped up since the grant of bail, the state may prefer an appeal against the order granting bail on the ground that the same is perverse or illegal or has been arrived at by ignoring material aspects which establish a prima facie case against the accused. In view of the aforesaid discussion, we shall now consider the facts of the present case. The allegations against respondent accused as well as the contentions raised at the bar have been narrated in detail above. On a consideration of the same, the following aspects of the case would emerge. The allegation against the respondent accused is under section 302 of the IPC with regard to the murder of the deceased Ram Savroop, the father of the informant appellant, who was a disabled person. Thus, the offence alleged against the respondent accused is of a grave nature. The accusation against the accused is that he overpowered the deceased, who was suffering from impairment of both his legs, pinned him to the ground, sat on him, and throttled his neck. As per the post-mortem report, the cause of death was ante-mortem strangulation. It is also the case of the appellant that the respondent accused is a person exercising significant political influence in the village and that owing to the same the informant found it difficult to get an FIR registered against him, that the accused was arrested only following a protest outside a police station demanding his arrest. Thus, the possibility of the accused threatening or otherwise influencing the witnesses if on bail cannot be ruled out. That the respondent accused had earlier preferred applications seeking bail under section 437 of the CRPC before the court of the additional metropolitan magistrate Jaipur on two occasions. The same came to be rejected by orders dated 23rd January 2020 and 6th March 2020. The accused had also preferred a bail application under section 439 of the CRPC, which was rejected by the additional sessions judge Jaipur Metropolis by order dated 12th March 2020, having regard to the gravity of the offences alleged against the accused. The High Court has lost sight of the aforesaid material aspects of the case and has, by a very cryptic and casual order, dehors coherent reasoning, granted bail to the accused. We find that the High Court was not right in allowing the application for bail filed by the respondent accused. Hence, the impugned order dated 7th May 2020 is set aside. The appeal is allowed. The respondent accused is on bail. His bail bond stands cancelled and he is directed to surrender before the concerned jail authorities within a period of 2 weeks from today. Stop.